right. I think we're live. Yeah. It looks like we should be live. So thank you everyone for joining this webinar. We are going to give everyone a few more seconds to join us. And while we get started, remember this is recorded. So you can always watch it after if you have to hop off or if you join late. Or you should also get an email with the recording after it is completed. And if you have any questions, feel free to throw them in the chat. We most likely won't be able to take any legal questions or give any legal advice on this call regarding your specific issue. We're mostly going to cover more general, broad topics. But you may want to reach out to Michael after the call or on his website if you do have legal specific questions or if you need his help. Now, the reason we're doing this, we get a ton of people, so DoorLoop, we are a property management software. So we're meant for landlords and property managers to manage their rental portfolio. And it also helps them with the eviction process. We'll get into that. But we get hundreds of thousands of people a month that are coming to these blog posts on Colorado laws and eviction laws, and they're asking us a ton of questions. So we felt it would be great to bring in an expert and real estate attorney. So today we are super lucky to be joined by Michael Larranaga, a licensed attorney from the state of Colorado. So Michael, thank you so much for joining us, and please introduce yourself.
No, it's a pleasure to be here, David. Thank you guys for reaching out to me, and great opportunity. So my name is Michael Larranaga. I'm a licensed attorney here in the state of Colorado. Basically, my practice involves real estate practice, which includes landlord-tenant issues, land issues, commercial land, leasing, and really the whole variety of the real estate world, including some personal property and litigation as well. Here in Colorado, we don't really have specialties per se, but we do tend to work in specific areas, and specifically, I'm more focused on real estate a lot more than anything else.
Awesome. Amazing. And I'll just a bit about myself real quick. So I am once again co-founder and CMO here at DoorLoop Property Management Software, author, legal CLE speaker, and real estate investor. So funny, hopefully I can add some to this conversation, but my last company was Practice Panther, which was a practice management software for lawyers. My wife's an attorney, all my friends are attorneys, so I have dealt with my fair share of real estate law as well. So hopefully I could be of some value to people tuning in. And this is just a quick agenda of what we're going to get into. We will try to go deep on a few topics, specifically landlord-tenant laws and issues, how to evict a tenant, can you evict a tenant, what are the grounds of evicting a tenant, how to prevent delays or fines by doing it yourself. We're also going to get into, should you do it yourself, can you do it yourself, what are the pros and cons of using an attorney versus doing it yourself. And we'll also get into the laws post-COVID. So much has been changing in this world, especially in legal. So we'll get into that. And we might, if we have time, maybe we'll get into like squatters' rights laws or rent increase laws. But once again, we're never going to be able to cover anything in this short time we have. So if you do have any questions, feel free to reach out and let's see if we can help out. So that is the start. I'm gonna stop sharing my screen here. So Michael, let's get into the first kind of topic. Give us a brief overview on some of the top issues that you see landlords and tenants are usually facing legally that you're dealing with on a weekly basis right now.
Before I go any further, let me just give my general disclaimer. Okay. Everything we're talking about right now is not legal advice. Don't rely on any of it. Contact an attorney. And I'm serious about that because the landscape is changing on a daily basis, especially after COVID. Okay. One of the big things that happened in COVID was that we had a bunch of statutes prior to COVID. Then we had executive orders from the governor's office, multiple state agencies, multiple local agencies, and multiple federal agencies. And so all those created this giant legal mess. And out of that came multiple new laws. And so when I tell you that it's changing daily, I'm not even slightly exaggerating. So please contact an attorney to get the most up-to-date information about your legal question. We're having a fun conversation during this podcast, but anything that we discuss, please just don't take it as legal advice. Now, all that being said, most common issues that I see in the landlord-tenant landscape, and I'm limiting this to residential, okay, are security deposit issues, improper accounting, rent increases are a big thing right now, late fees, and just overall temperament, okay? Like any other industry, there are good actors and bad actors, okay? There's good landlords and there's bad landlords, and there's good tenants and there's bad tenants, okay? It's not one side versus the other side. It's a mixture. Okay. And a lot of times just tend to see overlap where there's just general misunderstanding about the new laws, and that's creating a lot of issues for landlords and tenants on both sides.
And let me ask you, you mentioned accounting, improper accounting. Give me some detail on that.
Okay. So one of the new laws that was passed as a result of COVID and just kind of result of, let's say, bad landlording is that now every time that you do a cash payment, okay, so a tenant comes over to you, they hand you $100 bill, you're supposed to write them a written receipt and hand it to them. And you're supposed to keep track of that, okay? One of the big problems I see with landlords nowadays is that they get into the industry and they just rent and they collect the money and they don't really think a thought about it, right? So when you go to evict them, the big question is, did they pay their rent? Was it accurate? And are you entitled to anything? Okay. That's one of the major bases for evictions, non-payment of rent. And in order to prove that, you have to have clean and accurate accounting records. If you say, well, maybe they paid me $100 that day, but I don't remember, judge going to look at you and say, well, maybe you don't remember and they shouldn't get evicted. So that's really what it comes down to. It's keeping yourself out of trouble by documenting all the process. And what I call it is accurate and efficient and effective accounting keeping. Okay. You have to be accurate because otherwise it's just going to get tossed out. You have to be effective because the documents you're taking, they have to be usable in court. Okay. You have to be able to take a receipt and say, this is the receipt I gave them on this day. It showed them this amount and it's accurate because of X, Y, and Z. Here are all my utility statements. Here is the lease, and this is why it's accurate. Okay. And a big change that's many landlords aren't used to. Okay. So the standard default in the legal system is preponderance of the evidence. Okay. Meaning more likely than not. And typically when a plaintiff brings a litigation case, it's their burden to prove that more likely than not that they're right. Okay. On all the different elements and so forth in order to prevail on their claim. Right. In a lot of instances, that switches on the landlord due to statutory instances here in Colorado, specifically for security deposits, for example. Okay. A landlord actually has the burden of proving that when they withhold a part of the security deposit, that wasn't wrongful. That's not the tenant's burden.
Ooh,
so that's something that a lot of landlords don't realize, and they keep really shoddy accounting records. And when it comes to court time, they're kind of up against the wall because they don't have the documentation necessary to prove, yeah, I was actually entitled to that $3,000 I kept, but now I got to pay you triple damages because I wasn't keeping anything in line, right?
Wow. So what I'm hearing, and I love it, is overall you need to be super organized as a landlord if you want to have any proof to show a judge or a court that you're in the right here to evict a tenant. So you need to keep track, to summarize, of your lease agreements, your rent collection, everything. It was accurate. Maybe every notice you've given to the tenant, maybe by email, by mail, in person, everything. Just amazing, immaculate record keeping across the board. That sound fair?
Yeah, and this is why I love systems like DoorLoop and basically management systems. They automatically generate some of the paperwork that you need to help you keep track of some of this stuff, right? So when you get an electronic payment, you need to be giving the tenant a receipt, and you need to be keeping track of that, right? You need to be able to look at your bank record and say, okay, that specific payment came from this specific tenant on this specific date, because when it comes down to it, that's going to make all the difference in evicting a tenant, having them stay there, having a good tenant, having a bad tenant, really all integrated.
Wow. Amazing. Yeah, I mean, not to plug DoorLoop, but obviously, I'm wearing everything here, and I'm the marketer here, so I have to give a little shout out, So just a quick 10 seconds. If you are a landlord or property manager and you do use DoorLoop, everything's automated for you. Rent collection's automated, leases are automated, background checks, screening, accounting is fully automated. You could even sync with QuickBooks. I mean, everything is ready to go. So what I've heard from the team is whenever someone has to deal with an eviction, it's like one click, export all data, show it to the judge. Here you go. Case closed. It's a no-brainer. I had actually a funny story with my brother-in-law where his lease agreement was becoming due and expiring, and they wanted to kick him out and they couldn't find the lease agreement. They misplaced it. So they didn't have a copy of the original signed lease agreement. They couldn't really do much. So they were like hoping he would be a good tenant and like kindly leave or whatever it was. They got lucky he was a good tenant, but they lost their lease agreement. Like that's a big no-no, I'm assuming, right?
Yeah, I mean, so in Colorado, right, you can have oral and you can have written leases. Okay, both of them have binding effect. Okay, so if anyone tells you it's not in writing, it doesn't count. Don't believe that. It can definitely
Wow.
count if you tell
Wow.
someone I'll rent to you for X amount of dollars and they pay you money. That's definitely an agreement. Okay, so you guys just need to be aware of that. But when you have a written agreement, it does a couple things. Okay, it solidifies what the agreement was. Okay, so if you guys have an understanding, it actually puts it into writing and it makes it less ambiguous. Okay, one of the big problems when you're doing oral agreements is that he said, she said, it's the hearsay problem of what exactly was the agreement? Was it $100 a month? Was it $3,000 a month? We don't know because it's what you guys said is really who, and it really comes down to who is more credible. Who does the judge like more? Who does the jury like more? And that becomes a big issue because, it's like kind of throwing your hands up and saying, well, I'm telling the truth, but he said something different. So hopefully they believe me.
Wow. I mean, so I like what you said though, that if you're showing proof every month that they were paying you by Venmo, Zelle, check, whatever it was, $400. I mean, if there's cash, it's probably not going to be a lot of proof. But if you could show proof to a court that they're paying every single month consistently and then they stop paying, I'm assuming that's a decent enough start to do an eviction.
So really the way I approach litigation, right? I look at it of what exactly can you prove just based off the documents, right? What solid support do you have outside of your word that you can present to a judge? That way they can look at it and say, yes, that makes sense. Okay, I understand that. And then you start sprinkling in your word, okay? And that helps to build your credibility, okay? If you have supporting documents and you can do a document-driven case, you just naturally tend to be more believable, okay? If you present a receipt, a lot of times people just look at the receipt and say, okay, that makes sense. His story makes sense. That's the way I'm going to lean. And so you can be a very charismatic person and still be overcome by document load. And that's the way I like to approach litigation. So when you have a well-documented lease, receipts, you have proof of payments, all that stuff, that's the ideal litigation. Even if you're not the most articulate person on the stand, even if you get nervous, the documents really tend to help.
Got it. Awesome. And one thing you also mentioned is security deposit is the landlord's burden. And, from my personal experience as a landlord, you need to have very good inspection documentation. So when the new tenant comes in, make sure you go through the document. This is the inspection checklist. We're taking pictures. You're signing off on it. Everything is good. The blinds are good. The walls are good. You're just going through a checklist. And then when they depart, you do an exit inspection checklist with the tenant there. And you're saying, hey, this was good, good, good. But now these are bad, bad, bad. And you might not have to sign it, but like I have proof now to show a judge the before and after. And so far, so good on that point?
Yeah, I mean, the security deposit statute is an interesting one here in Colorado, right? It's CRS 3812-103. And basically, I've literally get it a couple of these now. And basically, the gist of it, right, is that when someone pays you a security deposit, is you're taking on a fiduciary responsibility, okay? Think of it like more of a trust account than anything else. It's not supposed to go into your bank account and go use it to go buy your evening dinners or whatever else. You're holding this for the client to secure damages against your premises, right? So when you document everything initially, you do that move-in checklist and the tenant signs off on it, says everything's good. What you're showing it, you're establishing an initial basis for what you should be expecting to get back. Now, one of the big things for the security deposit, you can't charge a normal wear and tear. So things like old refrigerators that just naturally go out,
Right.
normal walking on the carpet that needs to be replaced that's been there for 20 years, stuff like that. That just is stuff you can't charge. That's a burden that's got to be on the landlord. They got to take care of that, right? But at the end of it, you see a hole in the wall where they punched the wall. That's not normal wear and tear, right? So you can show a picture before and a picture after, and that documentation is all at the very end of the lease supposed to go into a very detailed written description, which you're supposed to give in a certain time period. Otherwise, you forfeit any right to that security deposit, and you're supposed to give it to the tenant. Okay. at that point, you can start discussing withholding money. Okay. And it's a big deal because some of these security deposits here in Colorado could be $3,000, $4,000, $5,000. And one of the aspects of the security deposit statute is, one, it's up to the landlord to show it wasn't wrongfully withheld. Okay. And there's two aspects. Okay. If it's willfully and wrongfully withheld, the tenant in certain situations is entitled to treble damages plus reasonable fees and attorney's fees. Okay. So what can be a $5,000 security deposit can easily become $20,000 case. Okay.
Wow.
$25,000 plus case, just by the fact that if it's $5,000 times 3, now you have to pay $15,000 for wrongfully withheld, plus their attorney's fees, which frankly aren't that cheap sometimes, especially if you have what I like to call he said, she said instances, and you have to do the document-based analysis and prove that everything what you're saying is accurate. It's a lot of discovery, it's a lot of upfront work, and it can add up to be quite a bit. So, I mean, you just got to be careful with that.
Yeah, I think the problem is that a lot of attorneys will take on cases for a tenant that have a good case on contingency. Tenant pays nothing. They pay nothing. Whatever they win, they give 40% to the attorney and everyone's happy. So as a landlord, property manager, owner, real estate investor, you need to protect yourself at all costs. Now I want to just kind of highlight something. Let's see if I could share my screen here live. Yeah. So you mentioned, inspection docs and stuff like that. So if you're on this webinar, you probably found it from our blog post. So you can go to our resources page, doorloop.com/resources. And we have a ton of free, 500 resources. Type in the word inspection and, how to complete an inspection. And you also have checklists. So like an inspection before tenant arrives checklist. And here's exactly, just download it for free and you go from there. Now, if I go back, to our blog that you probably came from, you could also search on the top right for like wear and tear, for example, if you want to learn about it. Now, granted, this is generic wear and tear advice, not specific to Colorado law, but they're pretty similar. And you could just learn here, here's the landlord's guide to wear and tear. What can you hold from a security deposit? Generally, you still want to check with your normal laws. Can you charge for carpet cleaning, damages? Like there's a whole host of things you can learn here. So, and there's videos. So definitely, go check those out. So, so let me stop. Well, actually, I don't even know if I was sharing that second part. Where did I cut off? Where did the screen sharing cut off?
No, I think you got it. I mean, you showed the link.
You got it. Okay. Okay, cool.
I'll like that.
Yeah.
The biggest thing with the checklist, man, take pictures, video it, document it. Just make sure that everyone understands this is what you're getting. This is what I should get back, less, just normal wear and tear. If you're renting for 10 years, of course things are going to go bad. But if it's a month-to-month lease, it should look almost exactly the same, right? It shouldn't be a big difference.
And what I would probably do myself, and I have done this before, is, the tenant could always say anything. Oh, that hole in the wall, that wasn't me. It happened after I moved out. So I like to walk into the apartment with my camera, recording, hey, nice to meet you, like showing the tenant is there. We're doing our inspection checklist, or even like wearing like a body cam, whatever it is. And, they can't say anything in court. Hey, you were there. This was the day of the inspection. You're in the video, and clearly this is what we found. This is the damages. So I go a little crazy with stuff like that, but because you never know. So I wanted to.
Turns out good for
crazy.
you.
Yeah. So Michael, I wanted to get into on what grounds typically can a landlord evict a tenant. You mentioned already not paying rent. Is there any other major grounds?
Yeah, I mean, this is a good segue, right? So basically, the big one, right, is non-payment of rent. If you don't pay rent, that's always going to be grounds for an eviction. Okay? So the no-nos are late fees. Okay, recently in Colorado, we had that big COVID issue, and we had all the different executive orders. And one thing that came out of that is the legislature took up the sting of saying can't charge late fees except in certain instances, right? So one big thing you can't evict for anymore is late fees.
You cannot evict for late fees anymore.
You cannot evict for late fees anymore.
Wow. Okay.
That's a big no-no now that people, I don't think really realize came out of COVID, but there's our limitations of what you can charge for late fee. Like, for example, max you can charge for late fee here in Colorado is $50 or 5% of the late fee due or the rent due, and you can't charge multiple late fees in the same rent. So there's a whole list, and I'm talking, it's like a 2-page list of stuff you can and can't do, things you have to do in order to charge a late fee, like giving written notice. So when you have a property software that complies with that list,
Yeah.
it really helps. Because at
Yeah,
this
yeah, yeah.
point, when I write a lease, I'm almost to the point where don't even bother with late fees, because you're only going to get $50 and you're taking on all this liability of potentially
Wow.
getting a lawsuit and having to pay attorney's fees, penalties, and it doesn't make sense for $50, right?
Yeah, what we tell people is like, look up the law and then plug it into our software because it's automated. If they're late by 24 hours, whatever it is, we can automatically add late fees to their bill, basically, in accordance with the law.
Yeah. So one of the big things is now you have to give written notice, right? So you can't charge a late fee till you give a written notice, and then you have to wait 7 days. So it gets complex, little things like that.
Yeah.
Right? But going back to your question of what you can evict for.
Let me pause you for a second there. Do you have clients that come to you throughout the year? Not like, I don't want to evict someone, but I just want to know, like, what should this policy be? What should I be charging late fees? Like, are you always consulting throughout the year with certain clients like that?
So this is one of the areas I've been trying to build up to on my SEO, on my website and stuff. I'm trying to get more landlords to come before the issue arises, right?
Yeah.
And have an actual attorney right there. Okay?
Right.
Colorado is not a landlord-friendly state. I'm going to be honest, okay? I represent both landlords and attorneys, landlords and tenants. And, it's not really landlord-friendly. And so one of the big things that a landlord needs to do before they start renting, especially expensive properties, is make sure you're complying with the laws. Make sure that you're not stepping out of bounds, making sure that you have all the stuff set up beforehand. Because really what you want a clean, efficient process, and you want to be on a friendly terms with your tenant. Because a lot of these issues that arise when you have tenants is poor communication by the landlord. Is that you have a landlord saying, well, it's my house, I'm going to do whatever I want. Get out of my house tomorrow. And then all of a sudden, now they owe this $5,000 fine because they kicked the tenant out, and now the tenant's back in anyways. So, I mean,
Right.
It's a lot of communication, okay? And I think that's something a lot of people miss. A lot of just being human, right? Yes, you want to document everything. Yes, you want to take the time in order to ensure that you're getting paid correctly. But if someone's going to be late by 2 days on their rent, maybe just let them be late by 2 days on their rent. Just say, hey, this one time I'm going to extend the rent. Send them a text to that effect. Can you please confirm? And that way you have documentation and you're still being kind to them and you're keeping that tenant happy. Because one of the biggest costs with renting is finding tenants, advertising, and so forth.
Yeah.
And right now in Colorado, property's hot, but eventually that's going to fall back away once they start building the apartments.
Yeah.
And we get the rental levels back up to where they need to be. It's going to start, you're going to need to start advertising. And that's always been one of the big costs. So this hot rental market everyone's seeing, eventually that will even out. So people just need to be aware of that.
I think what you said something very interesting. If there's ever, let's say, a late fee or anything you need to communicate, try to always do it in writing. WhatsApp, text, email, instead of call or in person, because there's no record of that. So, Your Honor, I told them 18 times. Not where's the proof? You everything in writing always. The second thing I gathered from that is getting good, accurate, current lease agreements in place. Because, we offer sometimes free agreements on our website, but they're just from the internet, eForms, or there's other websites you can get them from, but they're outdated. I can tell you when I was downloading those to put them on our website, the links were from like 2015. I was like, okay, I guess they don't update these. They don't update them. So at least the first time, like when I was renting out my properties for the first time, I hired an attorney for the first time. And then for that year, all the properties I used that one document. So I paid for it once and then I had it for the rest of the year. And then when laws changed, I just got it updated, and it wasn't that expensive to get it updated the second time. So that's my advice personally to those listening out there. Just make sure you do everything by the book the first time.
Yeah, so sorry, David. What I typically tell people is, factor into your cost of rent, right? You should have someone, at least that you can call, that in case something's going bad, you can say, hey, can you give me a free consultation, or can you help me with this, or can you refer me to somebody that can? Because the last thing you want to do is be in a bind and just kind of throw your hands up against, I guess I'm in a bind, because that's when things start to really snowball on you, right? And, if you could factor in the cost of lease review once every year or once every 2 years, put that into your rent. we're charging so much rent up here in Colorado. Sometimes it just makes economical sense that try to avoid getting a lawsuit because it's going to cost you way more on that end, and you're going to lose way more of the rent which you were supposed to be collecting versus just having some guy review it for you, right? And so that's why I typically say if you can have it reviewed up front, make sure you're at least starting off in a good place. Yeah, the laws may change, but you're starting in a good place. That's what I like to see.
Yeah, I also loved what you said, where it's like, it's 2 days, not the end of the world. Just have a good communication. I think communication is probably the biggest word, and relationship with your tenant, because what I've seen for myself and from friends is if the tenant is not happy with you and they leave, they're going to ruin your reputation, give you bad reviews online. It's going to be harder to fill that vacancy. And then in some buildings, the new tenant, once you find them, has to get approved by the board or the HOA if there is one. It could take you 3 months that it could be empty. Like, who knows? Try to just be a nice human being. Things happen, and roll with it, because you want to keep someone as long as possible in the unit without having turnover. That's the key word. You want to reduce turnover and increase occupancy as much as you can.
Once you find a good tenant, that's half the battle. Find a good tenant that pays rent on time, that's not going to destroy your place. You found the golden ticket. Just try to work with them. Don't be that person where I want to blow this up just because I want to blow it up. I mean, when you have someone who's going to give you money every month and just take care of your place, that's awesome.
Yeah, totally. I couldn't agree more. So, as far as grounds to evict a tenant, we have non-payment of rent. You can't do late fees anymore. What's like the number 2 or 3 reason? Is it like they're damaging the apartment, they're rude neighbors, they're causing noise complaints, they're getting in trouble legally? Is there anything big that you've seen a lot?
There's this concept of a substantial violation. Okay, and I don't want to go too much into it because it's a very complicated legal topic, and in effect, it shortens the type of notice that you have to give to them. Well, it typically involves like a major breach, like some type of breach of law. Let's say they're selling drugs out, or they're having some type of massive, I don't know, they're playing their music at all times of night. You're getting noise violations from the county and from the city ordinances. And you just have a lot of issues just with breaking laws and so forth. If there's a danger to health and safety, at that point, you start looking at the substantial violation area. And I'm forgetting if that's the actual term. It might be something similar, but it's definitely in the FPD statutes, the forcible detainer statute, which is the statute in Colorado, which used to evict people, right? So that's basically what you're looking at as a number 2. Number 3 is basically the lease just ends. So there's a couple ways to do that. So there's what's called a fixed term lease, okay? So let's say I'm leasing to you, okay? I'm going to set it for a 1-year lease. I'm going to start first of the year and end on the 31st of December, okay? At the end of it, I don't have to renew, okay? You're supposed to be out by the 1st of next year because your lease ended on the end of December, okay? So that type of thing, if they stay over on that type of instance, you actually have immediate grounds to look for eviction, right? Because your lease is ended. You no longer have a right to be there. Okay, there's some instances where it may roll over to a month to month, and when you have to start looking at giving proper notice again in order to terminate that lease. But if you're just looking at a strict fixed term lease, on that end date, your lease ends. Okay, and so then that point you have grounds to start looking for eviction. Okay, and one thing I tell everybody is when you're doing evictions, at least talk to an attorney, get familiar with the rules, because it is a very complicated process. It does tend to favor the tenants a lot. And I will say that there are a lot of tenant-leaning tendencies here in the court system. So you just need to be aware of that, right? I'm not bashing the court system here in Colorado or anything like that. What I'm just saying is that it's a very tenant-friendly state, okay?
Yeah.
So you need to be aware when you approach it that you need to come with good documentation. You have to come with a solid reason for eviction.
Right.
And you need to build your eviction.
Yeah. And don't give the tenant any ammunition against you, please. Be a good person, be a good landlord, do the right thing. So when it's time for an eviction process, what does that normally look like, and how long does it normally take?
So this is a hard question I get from almost every landlord I talk to.
Because it's so different. Every situation is so different. I know.
And I get so many angry landlords when I talk. Say, what? I can't get them out tomorrow.
Yeah.
Okay. So typically, what happens is that you have to give some type of notice, okay? And it's either a substantial demand notice or a notice to quit, something along those lines, some type of notice. And on the court website, they are called is it PDF forms or JDF? They're called JDF forms, and they give you a template to use in order for the landlord to fill out exactly what's happening, you have to put the property address, all that stuff. And you can post the notice if you're just looking to get them out, or if you're looking for attorney's fees and you're looking for help, there's some service requirements that you need to do under the forcible detainer statute. But in short, it starts with notice, okay? You have to have a reason to evict. It has to be a good reason, okay? That's what I always tell people. Don't start with junk because you're going to get junk results. Start with a good reason. Number 2, notice. And comply with your notice, okay? There's certain waiting periods that you have to wait for before you do things. Tenants have a right to cure, say, non-payment of rent, right? So you could post a notice saying that you haven't paid rent. I would like you out unless you paid rent, right? So they have
when you say post notice on their door, physically posting it?
Yeah. So when you post notice, okay, there's a couple ways to do it here in Colorado. Okay, one is actually literally posting notice. Okay, you take a piece of tape, put it on the door, and what I typically tell people, make sure you fill it out right, sign it, put the notice in a clearly visible place. I mean, right on the front door where they cannot miss it. Take a couple steps back and take a picture and show it's right there. Because what you typically see, you see this a lot, is people saying, well, I never got notice. It came off the floor. It blew underneath the porch. They hit it underneath the flowers.
So duct tape it to the door, basically.
Make it very apparent. And so no one can doubt that you put the notice right there. Keep yourself a copy because you're going to need to provide that to the court to show that you complied with this. And one thing about the forcible detainer statutes, it's very strict compliance. You have to do exactly what's in the statute or else you're not getting an eviction.
Right.
Yep. So, so good reason, proper notice, waiting for the notice to expire and making sure you have all that. If at the end of that you complied with that, and let's just take the rent instance and say they haven't paid their rent, okay? At that point, you can do your forcible detainer, okay? And that involves doing the complaint and servicing, basically getting a guy to go out there, probably a sheriff, and handing them the paperwork, okay? There's also another route where you can post on the door, but it comes down to, are you seeking attorney's fees? Are you not? What type of damages are you seeking? Are you seeking rent? And so forth. So it's a very complex, nuanced subject. So I would definitely talk to an attorney before you make any substantial moves here, because how you handle it and how you do service is going to affect your final outcome. Okay.
Yeah, you know, what I learned by writing over 100 blog posts on this is, like, if you're off by 1 day, you only gave 5 days notice, not 6 days. Like, just small things like that. Another attorney will eat that up and dismiss it or get you fined or delays or who knows.
And a lot of times these tenants are very knowledgeable. It's rightfully so, because it's hard being a tenant nowadays because it's expensive, right? And they have a lot of legislation protecting tenants, right? So a knowledgeable tenant, they don't even need an attorney because it's so tenant leaning. They can get an attorney, but a lot of them can do it themselves. So just because your tenant doesn't have an attorney, don't automatically think you're going to win and you're going to handle this by yourself. Because it's not always that way. Okay. If you get even someone who seems slightly savvy in the law, they can file an answer. It's not that difficult, especially if it's in county court. You go in and write the reason why you don't deserve to be evicted. Well, he says I haven't paid rent, and I did pay rent. Well, now you're going to have to go in front of the judge because that's a valid reason why you shouldn't get evicted.
Yeah. And is there like one or two major areas where you've seen landlords lose evictions or have delays or get fined for anything they're doing wrong that people should know about it and protect themselves?
Yeah, I mean, the biggest one I see for landlords, right? Let's just stick for the eviction thing, is improper documentation, right? You have to document, you have to do your notices correctly, you have to wait for your time periods, and you have to follow every single step in the forcible entry detainer statute. And if you do not follow that, you're going to have a bad day in court, right? You need to be able to go into that courtroom and show the judge, I did everything by the book like a good landlord should. Please get them out of there, and fingers crossed, that the judge is going to say, okay, it looks like you did everything correctly. Let's do that, right? And even then, if you go through this entire court process, okay, they could still pay the rent, and you have to let them go.
Yeah. I wanted to talk about that. I'm happy you mentioned it because that came up. So at least, with our software, you could disable rent payments. Like you cannot accept rent anymore. They can't pay rent online anymore. They're locked out. They cannot physically pay rent even if they tried. But where people get into trouble is if they don't have a software like this where they can just disable it, a tenant can just send the money with Venmo or Zelle or whoever else they were doing before, and then they're back in compliance, right?
So this is a tricky area, okay?
Yeah.
Because if you flat out refuse to accept rent, kind of on you, because they're trying to do
Ooh.
what they're supposed to do under the contract. And you're the
Ooh.
one saying, I'm not going to take your rental payment. Judge might just look at that and say, hey, kind of on you. If you want your rent payment, take it. Otherwise, you can go without taking your rent, I guess. Then you can stay there. So what I'm trying to say, what I'm trying to say is that you have to give your tenant an opportunity to pay rent. You have to act in good
Okay.
faith, and you have to let them have that opportunity. Okay. In Colorado, we have cure periods. So if they're late on their rent, you give them that substantial demand, right? Where they have the right to cure, where they could basically pay the rent within X amount of days without you filing eviction notice. You have to give them that right. Otherwise, it's going to go bad for you in court. There's also more statutes in the fourth container that if they pay before you get them out, I think it's before judgment, or it's not before the rich, before judgment, I believe. I would have to look at it. Is that you basically just end the proceeding. That's it. They paid.
Wow. So basically, you can give him hey, you haven't paid rent. You gave him a notice, 7 days. Hey, I'm giving you another 7 days to cure. Now it's 14 days. Hey, I'm starting eviction process. You're getting evicted. Here's a sign. You're in day 17, and day 22 before your court date, they pay rent. Oh, you got to drop everything.
I would be very careful in using the disabled rent feature. I would definitely talk to an attorney, okay? Because
Interesting.
I like the function. I'm sure it works in other states. Not sure if it's going to be the best.
But what you're saying, day 22 in my example, in the middle of the eviction process, they pay rent.
I don't want to commit myself to that, but based off what I'm remembering, I believe it's right before the enter order. If they pay their rent.
Oh, God. There's a certain deadline day that they can still get out of it. Okay.
Yeah, so
okay.
If they file against you, right, you file, the landlord files a complaint against you to get the eviction, right? If they pay before they get to that court date before the order is entered.
Wow. Okay. So let's move on to the next segment. We have about 15 minutes left. Is it possible for the average person to evict a tenant themselves? How hard is it? How much time and money does it take? And what are the pros and cons of themselves versus an attorney? It's a loaded question, but let's go with that.
It is a loaded question, okay? And I would say someone who takes the time to educate themselves in the law and understand it can do it themselves, okay? Typically, depending on the type of eviction you're doing, okay? If it's month to month, you're probably looking anywhere between a month and a half to maybe 3 months, depending on how fast you're looking to fast track it. There's some legal precedents here in Colorado that a property owner has a right to his property, right? So when they're evicting, they get a fast track process, will enter and detain a process. But depending on the type of notice you give, whether it's a 10-day notice or you have to give notice to quit, which could be 30 days, 60 days, or 90 days, X, Y, and Z, right? That's going to affect how long it takes in order to even commence proceedings, right? So the biggest question is, what type of lease do you have? Because depending on the type of lease you have, that's going to greatly affect how long it takes to get a tenant out. Number two, can it be cured, right? If the cure is just payment of rent, sometimes just asking for the payment, getting the payment, just letting it go is probably the best solution, right? And really the third question is, how difficult is it going to be? It depends, because we live in Colorado where there's a lot of college educated people, okay? I think per capita, I think we I don't want to start getting this. We have a very high educated college people here, right? So it's not uncommon to see a tenant who is very well educated in the laws, okay? And when you start getting that, sometimes you want to get that little bit of an edge where you have an attorney, And even sometimes then, the attorney could be ineffective, or they can be, you have a bad court date, it could be bad evidence, bad documentation. There could be so many things that go wrong. It's just sometimes better to have an attorney to help you sort through it. And even then, sometimes it doesn't work out. So what I like to tell my clients, okay, don't get frustrated. Take a big, deep breath. If you don't get them out the first time, try again until it. Okay, and sometimes that is not the advice people want to hear, but that is the reality of it, is that you have to be diligent, you have to be honest, you have to be truthful in what you're doing, and you have to provide good documentation and solve facts to the court and follow procedure. And if you manage to do all that, in theory, you should be able to get them out. I know it doesn't always work that way. I know that's not how it always seems to landlords, right? But in theory, that's how the law is supposed to operate. And that's how it should operate.
Yeah, so it's funny. For me, I look at it differently. I look at it purely based on an ROI point of view from time and money as a real estate investor. So for me, I see, hey, if I'm going to be doing it myself, it's going to take me 20 hours. How much is that time worth for me? Number one. Obviously, an attorney will be more sometimes than my time. But then number two, if it will take me 3 months, but it will take an attorney a month and a half, that month and a half, I just saved $4,000 in rent. That way covered the attorney's fees. So actually, I have a positive ROI from using an attorney versus not using an attorney. So for me, that's how I look at it. I don't know if everyone else does, but I always, kind of see the pros and cons on that opportunity cost, I guess you could say.
Yeah, that makes sense as well, right? If you look at it from a pure number standpoint, then how fast can an attorney get them out? How many times is it going to take to do it? I look at it from a difficulty standpoint, just because of the fact that you can do everything what you feel is right. Landlord, sometimes you still won't get the tenant out. So sometimes I feel that it has that nice little ring just to have someone in your corner to help you out sometimes, right? And just that convenience of having an attorney to help push you through some of the more difficult areas to help you get to the end of it, that's kind of what I'm here for, right? Because if you're an educated landlord, you can do this yourself, right? If you take the time, learn the laws, and do this, you can definitely do it yourself. But it's when you start hitting those sticking points, that's when it gets difficult. That's when you got to start thinking of, maybe I need to give another notice. Maybe I just need to stop what I'm doing and just talk to somebody and just, hey, do I just give another notice? Do I switch it to a notice to quit versus a substantial demand? What do I do?
Right. So let's get into the cost pricing question, because I'm sure people are going to be having. So I know every eviction is different, but average ranges, are we talking 1,000 to 10,000? Like, what's like the typical range that you normally see people fall into to hire an attorney to do the eviction for you?
Okay, are you talking my rates, or are you talking just in general?
Let's say you, for example, or you versus whatever.
Let's talk about me, because I don't like talking about whether attorneys will do, right? So what I typically charge is $250 an hour plus cost. Okay, that's my rate as of 2023. That may go up later on, and may go down later on depending on the environment. I typically base my rates something off of Clio or something like that, based off the median attorney rates in the area, right? So the way I look at this, right, you have a couple factors that play into it. What type of tenant do you have? How difficult is the process going to be? And what type of lease do you have, right? Because those three questions play into what type of experience you're going to have in court, how long it's going to take, how much resistance you're going to get. If you have the tenant that just basically, I am going to fight you tooth and nail every single second of the way, it's going to be more expensive. I mean, that's honest, right? Because a tenant who doesn't resist and just says, okay, I didn't pay my rent, get me out. It's the difference between a default and just getting an order, just getting a writ, and potentially just making an agreement with the tenant, just leave on this day and just, otherwise you're going to take this to court and you're going to get an eviction on your record. Otherwise, you're going to keep it suppressed and you don't have to worry about it, versus we're going to fight every step of the way. We're going to take this in front of the judge.
That's actually interesting. I forgot about that. That's some ammunition you can use, obviously, to get someone out. Hey, if I go through this eviction process, it's going to be on your record forever. It's going to be very hard for you to ever find another unit. Yeah, great. Okay, let's keep going.
Yeah, so here in Colorado, just to build off that topic, typically evictions are suppressed until you get an outcome saying, yes, you can evict. Okay, once you get the writ and it's public and you guys don't have a side agreement saying you're going to suppress it, it's out there, right? It's out there. And that's not fun because every landlord that's going to look at you now looking in the future going to say, oh, you have an eviction on your record. I think I need to call your prior landlord and ask him why. And you're going to say, oh, So, but that's a big no-no, right? So an alternative that works a lot, right? And just simply talking to the tenant, saying, you're not paying your rent, okay? We're going to evict you, whether you like it or not at this point, unless you do pay your rent, or whether you stop committing crimes in this house, or whatever the reason is. Right? And a lot of times, you guys can do a little side agreement where they leave on X date, even during the middle of litigation, and it remains suppressed. Okay, and that's a big thing for them. If you can't find it on the public record, that means it's not on your record. There's some thing about lying on application forms and so forth, but if it's not an official eviction because you kept it suppressed, you just came to an agreement, that's a different thing than getting evicted, right? So there's nuances in every way you approach this. So it really depends on, I would say cost will depend on how far you're going to take it, okay? If you're going to take it to default judgment, meaning they're not fighting you, you may be looking at $1,000, maybe $2,000. If they're going to fight you and you have to take it pre-trial, it could be $5,000, $6,000. I don't want to give exact numbers because it really depends on the situation, right? But if you take it to trial, it depends on the complexity, right? Is there a fraud to it, right? Are they lying and basically trying to say they didn't pay or they paid their rent? You're saying, no, they didn't. Well, you have to prove that, right? How much discovery is needed? How much work is needed? How much legwork is needed in order to get them?
Did they hire an attorney also to represent them? Yeah, right.
If you hire an attorney, it all comes down to how much work is that attorney going to have to put into your case to get them out? And like I said, my rate's $250 an hour plus costs, and that's the way I look at it. I'm charging a reasonable hourly rate. I'm fairly fast as a worker, so I'm not dilly-dallying and just running up costs for the fun of it. I'm actually putting in labor. And so that's what I consider reasonable, putting in reasonable effort, reasonable hourly rate, and whatever the outcome is the outcome, right? And, some attorneys will tell you, well, you can do a fixed fee and so forth, but it just depends on what type of case you're looking at. Because there are some tenants that they're going to be honest, and that's the best thing. And, a lot of times you can work with those tenants, you can get them out on agreement, suppress the case, and it's not a big deal. It really came down to you guys arguing over $100 security deposits, and not a big deal. Other times you have a tenant who just flat out says, I paid my rent, but they didn't. Now you got to prove it. That's a big old thing.
Right. I'm assuming that if the landlord wins the case and hires an attorney, they can use the security deposit if there's anything left over for the attorney's fees.
In certain situations.
Okay, I don't know if I want to get further into that. Okay.
When it comes down to service as well, like we were talking about before, having certain. So the way security deposits work, right, is more for damages, late rent, past due utilities, and the big kicker was that you have to make sure you document everything in order. Once that tenancy ends, you have to give them that detailed written notice of why you're keeping any portion of it. It has to be a valid reason. And, like I said, attorney's fees are one of those big questions of, did you do everything right? Are you entitled to attorney's fees? And the big question I would have is does your court order say attorney's fees?
Got it.
One, does your lease say it, and does your court order say it? Then you can start thinking about, what am I going to do with the security deposit once they're out?
Got it. Now, let me ask you, probably the last question we got to wrap up is, I'm assuming, people will probably be contacting you for a few questions after this. They don't necessarily have to hire you for an eviction, but people can also hire you like on an hourly basis or a consultant basis to, like, if they want to hire you for 3 hours to just ask you a million questions and get some advice and docs, you do that also?
Yeah. So, I like to do more task-based, right? If you want me to review your lease, you want me to give you comments on a lease or your right to a lease, that's definitely okay. I definitely do the free 30-minute consultations for people who have general questions.
Wow.
And, I don't give out free legal advice because it's a malpractice risk to me. So unfortunately, I can't do that because it's too big a legal risk to me. But I will at least point you in the right direction, right? If you need a different type of attorney, let's say you have an issue that's not really landlord-tenant, but it comes out of a landlord-tenant relationship, such as, for example, liability. One thing I tell people when you're doing the rentals is that maybe consider an LLC, and I help set up LLCs all the time, but where you stick that rental into an LLC so to help protect yourself a little bit from the secondary risk, right? So really, they're going against the house, they're going against the rental payments versus going against your own personal job. So there's a lot of factors and a lot of different discussions we can have. It's just kind of what you're looking for.
Got it. Okay, understood. Now I'm going to try to throw up your contact info on screen. Is there anything else you wanted to cover before I threw that up?
I don't think so. I want to thank you for giving me the opportunity to talk here. And,
yeah, it was
everyone
fun
out there listening, it's a difficult world. I get it, guys, and sometimes when I talk, I sound gloom and doom, but I'm actually a very upbeat, happy guy. It's kind of just the nature of the thing.
Not at all.
It's a hard thing being a landlord in this world. It's a hard thing being expensive for both of you guys, and just be nice to each other, man. Have a humane relationship. And that's all we can ask from you guys. And we'll figure it out on the legal end on the back end. And just good luck with everything, okay?
I love that. I love that ending. So let me see if I could share up this last slide. There it is. So that should have your email, and it should have your phone number. And if someone can't see it for any reason, the email is larranagalaw, LARRANAGALAW @gmail.com, and phone number 720-651-2690. And your website is larranagalaw.com. Is that right?
Yes.
Awesome. Wow, this is great. A lot of great information here, Michael. Thank you again. And for those landlords that are interested in checking out DoorLoop as your property management software to protect you in the future, we also invite you to check us out, doorloop.com. You can just schedule a free demo, ask as many questions as you want, how we protect you, how we help you find new, better tenants in the future. So always happy to help. Thank you again for tuning in. And one more thing, if you do want to learn a little bit more about laws or anything like that, do your own research, look at his website. We also have a lot of material on our website. And specifically, we also have webinars and podcasts on our website. So you can go to doorloop.com/webinars or doorloop.com/podcasts. And if you're a landlord, real estate investor, property manager, you will find a wealth of information there that I'm sure you will love as well. But I think that wraps it up for now. I'm seeing a ton of questions in the chat. We are out of time, so unfortunately we can't take any of them. But please reach out to Michael if you have any of those questions. He does have a 30-minute free consultation, but he can't give free legal advice. Remember that? So he can only guide you. So it's more like, hey, can I evict someone? Okay, can you help me? Stuff like that. But I think that's it for now. Michael, any final words? All good?
All good. You guys have a great day, okay?
Awesome. All right, Michael, stay on for one more second. Let's just end this real quick. All right. Thank you, everyone, again for joining us. Take care.